Regarding trademark, already we have discussed four questions with their relevant answers. And regarding question 5 of trademark, the very question is discuss the salient features of Indian Trademark Act. So, before discussing the very salient features of Indian Trademark Act of 1999 will toss a brief history behind the enactment of the Act, and in that connection we'll discuss the Trade and Merchandise Act of 1958 and how it led to the very enactment of Trademark Act of 1999. So, regarding the Trade and Merchandise Act 1958, which has been replaced or refilled in the Trademarks Act 1999, passed after taking into consideration developments in trading and commercial practices in the country since liberalization. The new act is meant to amend and consolidate the law relating to trademarks to provide for registration and better protection of trademarks for goods and services and for the prevention of the use of fraudulent trademark. So, the very trademark law in India is now contained in the provisions of Trademarks Act 1999, the earlier Trade and Merchandise Act 1958 has been repealed. The object of this act is to confer protection to the user of trademark on his goods and prescribed conditions for acquisition and legal remedies for enforcement of trademark rights. The definition of trademark as defined in the Indian Trademark Act means a registered trademark or mark used to identify the origin and manufacture of the goods, and the Indian Trademark Act 1999 provides for registration of trademark with the Register of Trademark. For the purpose of registration of the trademark, India has been divided into four zones. The trademarks offices are located in Mumbai, Delhi, Kolkata, and Chennai. Application for the registration of trademark is to be made by the trademark attorney and on behalf of the examined by the on behalf of the owner of the trademark. After the application is processed and examined by the trademark authorities, it is advertised in the trademark journal issued by the trademark registry at Mumbai for inviting any objections. If no objections are filed within the period of 3 months from the date of advertisement, the Register of Trademark may register the trademark. So, Section 18 of the Act provides for the procedure for making an application for registration. So, regarding that, we'll discuss also certain amendments, and in relevant amendment, one is Trademark Amendment Act 2016, and in particularly the National Industrial Classification, and by giving a 12-digit unique identification number, which is otherwise called a NIC number, to the particular trademark which is registered, and it is otherwise called Udyog Aadhaar scheme. So this is also very well known as NIC code or National Industrial Classification. And as regarding that, the very goods which are under the Trademarks Act 1999 are falling under public goods, private goods, common resources, and club goods. So there are four particular categories of goods which are registered under the Trademarks Act 1999. So also services are classified. So classification of services under which falls the therapy sessions, babysitting, surgery, house cleaning, haircuts, teaching, legal advice, etc. And all these goods and services registered under the Trademark Act 1999 are otherwise called as offerings. Why? Such providers of services or those goods manufactured by such manufacturer. So the very Trademark Amendment Act of 2016 particularly provided that all these should be having a particular NIC number, and that NIC number is otherwise called National Industrial Classification number, and it is a 12-digit unique number. So in that regard, we'll discuss the very trademark amendment rules of 2017, and this particular amendment rules of 2017 described and defined and provides provisions regarding small enterprises, startup or individuals, those who are eligible under the Trademark Act 1999 to be registered to pay lower fees for registration. And as such, the 2016 amendment made expanded the very scope what can be registered as offering greater flexibility and protection for new types of trademarks and stricter penalties for infringement. And it also made classes, and such classes which are falling under 45 classes as under section A2U with subdivisions 1 to 99. And as regarding that, we will discuss certain classes here, such as class 1. Such goods which are falling under class 1 are chemical products used in industry, science, agriculture, etc. And regarding class 2 goods, paints, varnishes, preservatives against rust, and all such products are falling under class 2 and regarding class 3 goods. The goods are cleaners, detergents, bleaches, polishes, soaps, toothpaste, perfumes, oils, hair, lotions, etc. And under class 4, those goods which are falling under class 4 are industrial oils, grease, lubricant, fuels, candles, etc. And as regarding class 6 goods, metal goods, hardwares are falling under class 6 and regarding class 7, such goods are machines, machines tools, motors, engines, agricultural implements, automatic vending machines, etc. are falling under class 7 and regarding class 8 we found those goods like hand tools, cutlery, razors, electric razors, hair cutters, etc. And as regarding class 9 goods, we found apparatus and instruments for scientific and research, audiovisual information technology, etc. And regarding class 10 goods, those which are classified under class 2 are surgical, medical, dental, veterinary, artificial limbs, orthopedic articles, etc. So here we only discuss about certain class, and as such there are 45 classes with subdivisions 1 to 99 as we found under section A to U. And now we'll go to another important amendment, and that is relating to 2019 amendment of the Trademark Act of 1999, where it is provided new adjudication mechanisms, and the very section which are inserted under this amendment, section 112A, which deals with criminal penalty, and section 112B, which deals with the appeals provisions, and finally the Parliament of India and the Union government enacted the Jan Vishwas Act of 2023, which exactly aimed at decriminalization and rationalization of offences and provisions in Copyright Act of 1957, Indian Patent Act 1970, Trademarks Act 1999, and also Geographical Indication Act 1999. So, the very important points under the Act that we have touched, one is the register of trademark, and another one is the trademark attorney who made application for registration on behalf of the owner of the trademark or group, and trademark journal where it is being published for any objection from any person, then it is registered under trademark registry. So now we'll go to the very salient features. So the very salient features of trademark. So first one is the definition of trademark. So the definition of trademark to include registration of shape of goods, packaging, and combination of colors. Trademarks shall now include services as well. All 45 international classification of goods shall now be applicable in India as well, and it would be possible to register trademark in respect of service categories, and after that we will deal with the very single application, and the single application for registration for same mark for multiple classes is provided under this act. And the third one, that is relating to use of foreign trademarks. So, in relation to that, use of foreign trademarks in India is permissible except in cases which involves direct royalty payments in foreign currency. The permission of the Reserve Bank of India is not required for use of foreign trademark which does not directly involve payment of royalty to the owner of that foreign trademark. Proprietors of foreign trademark who register their trademarks in India must use it in relation to the goods in India, either directly or through a local collaboration in India. Non-user of such trademark in India may result in cancellation of the trademark. And the next one is that use of hybrid trademark. It is another salient feature of the Act. So, the use of hybrid trademarks is permitted in India. Such foreign trademarks registered in the country of its origin are registered jointly with the trademark registry in India along with the trademark of Indian party. And the next one, that is prohibits reproduction or imitation. This is another salient feature of the Act. Prohibit registration of a mark which is merely reproduction or imitation of a well-known mark, even in respect of disparate goods or services. Any mark which takes unfair advantage of or is detrimental to the distinctive character or reputation of a well known trademark is not entitled to registration under Section 9, and such use would amount to infringement of a registered well known trademark under Section 29. And now we'll go to the next one, that is permitted use of the trademark. So, permitted use to include use of a registered trademark by an unregistered licensee is allowed. And our next important feature is comparative advertisement. Comparative advertisement is permitted. And the next one is relating to offenses which are committed under this act are cognizable. So, making offenses relating to falsification of trademarks and application of false trade description are cognizable. Police are empowered to search and seize goods or other instruments involved in committing an offense. And the next important feature is that is regarding scope of infringement is widened. So, another most important salient feature of this act is that the scope of infringement has been widened. For instance, use of a registered trademark as a part of a corporate name or use of a mark which is identical or deceptively similar to a registered trademark, even in respect of disparate goods or services, will be regarded as infringement of a trademark. So, the last one, that is the most important salient feature, that is the Trademark Act 1999 provides that the period of registration is 10 years, permitting filing of multi-class applications, registration of collective marks and trademarks for service. And in that connection, we would like to finish with an important leading case, and that is Daimler Benz versus Haibo Hindustan. So, the very instance case, the defendant Haibo Hindustan trader used well-known markup plaintiff Daimler Benz. Three painted human figures in a ring characterize the characteristics of three pointed star to promote its VIP bench garments. The court issued interim injunction to defendant to stop using the mark as it means unfair use of well-known trademark under section 2 clause ZG of the Trademark Act 1999. The court added that the benchmark is well known in the market and the defendant's use of that mark is deceiving the ordinary customer. It is basically a fake system of marketing and causing injury to the plaintiff. So, as we discuss those salient features, so also the very act of Trademark Act of 1999, and before the enactment of this act, the previous act that also we have discussed in brief, that is the Trade and Merchandise Mark Act of 1958, and all these amendments made in regarding 2016 and those amendment rules of 2017 and the Amendment Act of 2019 and 2023, the Jan Vishwas Act of 2023, and another important leading case, that is the most important leading case relating to Trademark Act, that is the Daimler Benz versus Hebo Hindustan. So, this would be the appropriate and correct answer to the very question, and that is question number 5 relating to the salient features of the Trademark Act of 1999. So, in our upcoming video, we will discuss the last question relating to trademark, and that is question number 6. differentiate between trademark and infringement and passing off.